All right, well, welcome. We're with David Lowe of Lowe Dreesen Miller. My name is Mike, and today we're talking about estate planning. And David, thanks for taking some time with us today. I guess the first question I have is, and I've been thinking about this myself a lot, for myself and for my family, my son. And what age do you want to start thinking about estate planning? Is that something that is just for older folks, like over 60? Is that for younger folks? What age should we be thinking about estate planning in our lives?
Well, Mike, it's great to be with you as always. And that's a great question. I think one that often is not thought about soon enough in folks' lives. But I think, one easy way to think about it, and it depends really on what someone's doing, right? If someone has a really dangerous job, maybe they're in the military. We're in a large military community here around Fort Leonard Wood, Missouri. But if they're in a dangerous job, they're going overseas, maybe fighting for their nation, or going to put their life at risk. Well, maybe even as a single person, you need to think about at least having some powers of attorney in place and some other documents in place that would, a will, that would be able to transfer your property if you did, pass away, or if you were incapacitated. The powers of attorney would come into play for your loved ones, whether it be your mother, father, brother, sister, whoever, who may be able to assist you if you were incapacitated in any way. Generally speaking, however, it's not as important for a single person without children, maybe with very, very few assets. Maybe they own a vehicle, but they don't own a home. They're renting an apartment, something along these lines. That's probably not a category that's a high risk or in great need for an estate plan. But if you turn the tables 10 years forward, and that person, that single person, let's just say it was a guy, for example, if that man got married, he has kids, he begins to develop his asset base, and now he owns a home or he's paying a mortgage on a home, a couple of children, maybe they're 2 and 5, with a wife. Well, I think his life changes there that we've just mentioned are significant. And now I think he's in a category of people that need to be thinking about an estate plan, because realistically, you need to think about it. Let's just use the man, for example, as a head of the household. Let's just think about it from that perspective. What happens if he were to become disabled? What happens if he were to pass away? What happens if he were to lose his job for some reason? And then, again, whether it's a physical or a mental or some kind of other disability due to illness, what happens if he cannot provide like he has been providing for, say, many years in that marriage, taking care of his wife and children? Again, part of an estate plan speaks to those issues. Part of it ensures that you have a plan in place to care for your family and make sure that whether it be proceeds from a life insurance policy or your assets that you gain, whether it's a investment account, a bank account, a piece of real property, a vehicle, other types of assets that you may acquire over time, go to your loved ones upon your demise. So that estate plan becomes, I believe, much more important once you're married and you begin having children, raising a family, and that type of thing. So hopefully that's a general introduction. Now there are many more unique and maybe even complex needs as folks grow older. We could get into that, and yes, we could argue that even more sophisticated estate planning may need to be done for those folks as they get into not just their retirement years, but years where they may end up needing long-term care. That brings into a whole nother conversation, different circumstances that may arise in their lives, which again, a comprehensive or complete estate plan would address those needs as well. So again, you can see from an early age, maybe in your late 20s to your early 30s, all the way up until your retirement age, say mid 60s to mid 70s, and then beyond, estate planning is, I think, an invaluable tool for people to protect their assets and look towards the future to take care of their loved ones, their beneficiaries, which would ultimately be their heirs at law. So,
okay. So a couple of quick follow-up questions to what you just said there. So I think what I heard you say, and correct me if I'm wrong, is that even if I don't have a lot of assets, maybe, don't even own my car, I'm making payments on it or whatever, but I don't have a lot of assets, live in an apartment, but I have children, that would immediately mean that I should have some sort of a estate plan in place, or we'll talk about terms in just a minute. We'll define terms, but you should have some sort of estate plan or a will or something in place if you have children, even if you don't have a lot of assets, right? Because the children need to have some continuing care that you have directives on that, right?
Yeah, Mike, I think you're right. You're getting to that point, and I'd say, you don't have many assets, but I'm sure they're going to have a car, right? In our society, most people have vehicles, and they're going to have a bank account. And those same folks may or may not have some benefits from a job, but maybe they do. Maybe they have some sort of retirement plan, possibly life insurance. And then beyond that, maybe they're renting at that point. But still, like you said, you have young children. Maybe that example I gave, 2-year-old, maybe a 5-year-old. Well, they're not going to be of the age majority for at least 13 and I think in that case, maybe 16 years under that hypothetical. Well, what are we talking about with an estate plan for those folks? That covers the basics. The basics would be, well, you want to make sure that your assets pass to your loved ones outside of probate if you were to pass away. So you have a seamless distribution of your assets to your loved ones, in this case, to your spouse. The other thing you mentioned is true. If you've got minor children, you want to make sure that you've designated someone to take care of your children. And we call it guardianship, to be guardians over your children if you and your spouse were unable to care for them. Or in the case of a single person, most especially, if they didn't have anyone else to rely upon, meaning a spouse isn't in the home, then obviously they'd want to have, and we set those forth in a will. A will would address who you want your guardian to be should you pass away of those minor children. So again, those are some of the things, even in a simple situation where you don't have a large estate, you don't have various pieces of property or a business, or you haven't been working for 30 years and you have a large asset base to be concerned with. Even in those, you want to call it early days of your raising a family and such, there are significant consequences if you didn't have anything in place. So that's why I think it's always a good idea to talk to an estate planning attorney, someone who does this for a significant portion of their practice and has a good understanding and knowledge base to be able to guide and direct folks in those situations.
Okay, great. So we kind of launched into this whole discussion about what age and what precipitates the need for an estate plan. But let's take a step back. I think my understanding is an estate plan is kind of an umbrella term that covers a plan. Can you give a little bit more definition or a little bit more insight on what an estate plan entails, and a little bit about who needs one, or how you would proceed in helping someone establish an estate plan?
Yeah, Mike, I'm glad you brought that up, because I do think it's confusing. I don't think the average person really even understands what an estate plan is. You could ask someone, well, have you ever done any estate planning? I don't really think they know what that means. They might say, yeah, I have a will. Maybe they say, no, I don't have a will. Well, does that really cover an estate plan? It really doesn't. Estate planning is somewhat multifaceted. Really, you can almost start with the fact that you sit down and talk to an attorney who regularly practices in this area of law, and they are going to be able to provide you with insight and their experience and knowledge into how you can protect your family, how you can protect your assets, how you can avoid probate, how you can look to the future to ensure that your family is protected, your assets are protected if something were to happen to you, whether that's if you were to become disabled, if you were to become incapacitated, or if you were to die. And that really, the concepts within that, the documents within that process that an attorney who works in this area of law, wills, trusts, estate planning, that is where the attorney can really assist any individual or couple in planning for their future. So I guess that would be at first blush, I would say that would be a good definition for estate planning. It's looking to the future, it's protecting your assets, ensuring your assets aren't subject to probate, and it is planning for your heirs to be able to receive your assets seamlessly if you happen to pass away. These are some of the concepts that are involved in estate planning.
Okay, so is there a difference? So some of the terms that I've heard when it comes to estate planning, and you've mentioned a will, and you've mentioned, I think you mentioned a trust. Are those two separate documents, or is that one and the same? Or some people need a will and some people need a trust, or do you typically have a will and a trust? Can you speak a little bit about that?
Sure. And again, great question, because this question comes up regularly in my practice as I advise clients in this area of the law. Wills, last will and testament are very common, and they are almost always a part of an estate plan. Trusts, revocable living trusts, there are a variety of trusts out there. Special needs trust, pooled trusts, Medicaid asset protection trusts. There's a variety of trusts, and really until you understand the client's needs, the client's situation, it's hard to ever know at the outset what might be of benefit to them. But trusts are separate from wills, to answer your question, and they are necessary in many situations, but they aren't necessary in every situation. So there again, having an attorney who looks at your case, who looks at your family's situation and is able to advise you, they're the ones who are going to be able to inform you whether you are a good candidate for a trust, and if so, what type of trust, in addition to the will. And that is, those two documents in particular are looking at the future if you were to pass away. There are some circumstances of trust and provisions of a trust have provisions in there if you were to become incapacitated, but they're primarily looking at the concept of how to protect your assets from probate, how to pass them seamlessly to your loved ones upon your demise, and very uniquely in trust situations, how to provide for unique situations in your family, how to, again, whether it's property, whether it's assets, or other things that might be involved, businesses, in your situation, trust can address those needs. So again, they work hand in hand in many cases, but they are separate, they're independent, and they each have their own specific purpose. I don't know if that helps you understand, but I think that's a good, if you will, introduction to what those types of documents will accomplish for you.
Okay. Yeah, that's very helpful and very well articulated. I think we'll maybe do another episode with some further details, but let me wind this up with kind of a couple summary questions. So what I'm understanding is estate planning is not like someone trying to sell me a convenience, sell me a hot tub for the backyard or something like that. Estate planning is really essential. You mentioned before that there are consequences of not having an estate plan. Excuse me. There are consequences of not having an estate plan. Talk a little bit about that. I mean, this isn't just something that Lowe Dreesen Miller is trying to, sell the public and make a little extra money. This is something you care about the people in your community, and you don't want them to suffer the negative consequences of not having an estate plan, right? And so what are some of the consequences that can arise if a person doesn't have an estate plan in place and they are, they do become incapacitated or they do pass away suddenly? Why is it important, and what are some of those consequences?
Yeah, again, I'll touch back kind of on what we just talked about and build on it, but the importance is very clear. Again, These documents and others, and I'll touch on a couple other documents in a moment, but these documents are designed to ensure that your assets are protected. We've all worked long, hard, and in many cases, folks work for 50, 60, maybe even more years than that to accumulate certain assets. And at the end of their life, the last thing that they'd ever want to happen would to have, say, for example, their loved ones to have to go to court, maybe even have some kind of a contested case in probate court over assets because they failed to make clear what their wishes are regarding those assets. They failed to protect those assets from being subject to probate because they didn't make proper designations. Just to use a common example is your real estate. If you own property or you're paying on property, you're an owner of it, but you're paying on it, meaning you have a mortgage, you're still going to have that property subject to probate if you don't have a deed prepared, which will ensure that that property will pass to your loved ones, either directly or through a trust or through some other way upon your demise. And one thing that I can give an analogy on is any other asset. We use the same type of conveyance techniques. We're trying to pass assets such as a bank account, such as an investment account, such as a vehicle, trailer, RV, boat, whatever it is that you have. We're trying to utilize the statutes in the state that the individual is. Here in Missouri, it's section 461 under our revised Missouri statutes that allow folks to pass these assets to their loved ones, to their heirs, upon their demise without them being subject to probate. So again, you're protecting your assets, you're protecting your heirs. You're ensuring they don't have to go to court and that there's not going to be a big fight about it, like who gets what and in what shares. There's not going to be money spent dealing with the court system in ensuring that your loved ones receive your assets. So wills, trusts, and deeds ensure that that happens. And again, as I mentioned before, typically this means when you pass away. But there's a whole nother aspect to estate planning that's very important. And as we know, people are living longer every year. It's obvious. People live into their 80s regularly now. That didn't happen 50 or 75 or 100 years ago. People are living much longer. I think the average age now is well into their late 70s or early 80s for a man, and a couple of years older than that for a woman. What does that mean? Well, what that means is that invariably, as you live older, the chances for you to contract a debilitating disease such as dementia, Alzheimer's, cancer, the odds go up. And we know from our own life experiences that many people do contract these diseases. So the important point that I'm trying to make is another component of an estate plan that's very important is if you're alive but you become incapacitated, you become disabled, you're unable to make decisions for yourself or go to the bank for yourself as you once did. If you can't make financial or healthcare decisions, you need to have durable powers of attorney in place to make that or those decisions. Again, very important part or component of an estate plan, and one that we always address with folks when they come into our office. And I can take that one step further on the healthcare side of things. Sure, it's important to, and we recommend that an individual get as a part of their estate plan, a healthcare power of attorney, meaning a power of attorney for healthcare decision making for someone to stand in your shoes and make decisions for you should you become incapacitated. But concurrent with that, I always address with my clients, what if you are at the end of life? What if you are in your dying days? What if you're kind of in that what we call comfort care or hospice type stage? If you're in that situation, of which we've all known someone going through that before, you're going to want to have a living will. You're going to want to have a what we call a healthcare directive, which very clearly spells out what you want and what you don't want under those circumstances. Thus, if you have that in place, that will alleviate the pressure, the stress, the anxiety on your loved ones to make those decisions for you. It will be clear. It will be in writing. The healthcare providers attending to you will have to look at that document and respect your wishes. And then your loved ones won't have to worry about, well, would he want or would he not want to be undergoing this type of treatment, just to keep him alive if he's terminally ill. So again, another component of that healthcare durable power of attorney is the healthcare directive, the living will. Those are documents that are very important as well. So I just wanted to expand that a little bit. The conversation meaning, if you're alive but you're incapacitated, what are steps that we take to ensure that those potential consequences or circumstances are addressed? And those are the ways that we do that.
Okay, so that sounds great, David. A lot of things to cover there, and we'll probably be doing some future episodes, some future programs to cover more of those things, the durable power of attorney and the healthcare power of attorney. Some of those very important elements, we'll probably do whole little episodes on those, because there's a lot to cover there, and they're extremely important as life twists and turns sometimes show us. So this is all good. So if my wife and I are thinking about, hey, it's time to put an estate plan together. We don't deal with lawyers very often. We don't deal with attorneys. And so how does the process work? We call your office and we say, hey, we're ready to put an estate plan together. Talk me through the process, and, maybe you can't give it exact pricing because each situation is different, but give me maybe a ballpark idea. Just what am I facing here, and how does the process work?
Yeah, so it's a great question, because Mike, I talk to people all the time that don't deal with attorneys, and been a lawyer for 34 years here in about 3 months, and I in that 34 years, you can just imagine I've talked to thousands and thousands of people, many of which have never had the need, thankfully, maybe we'd say, to talk to an attorney. So it's often uncharted waters for folks. So the first thing we do, which I think is a tremendous advantage to our clientele, is we never charge for an initial consultation. I always give at least up to 1 hour of free consultation on these types of matters, which is usually sufficient time to go in depth into the conversation we've been having today, to go in depth into what they may or they may not need. And I'm talking about a couple such as you and your wife in the area of estate planning. I get them first to fill out once an appointment is made, maybe before the appointment, or I try to have them fill out a fairly involved questionnaire, which gives me an idea of what type of assets they own, how many children they have, and without going into great detail, some of their goals in estate planning. What are their special circumstances I need to be aware of? So I'm at least aware when they walk in what's going on with them. And then we sit down and talk about it. We get to know each other, and eventually over the course of that, typically an hour, we're going to be able to identify their specific needs, their specific goals. And then I'm going to, with their assistance in providing me the necessary information, I'm going to tell them what I believe would be an effective estate plan for them. Now, every situation is unique. We know that. Everybody comes in with their own unique situation. So it's extremely difficult to be saying how much something costs until I talk to them. But we are very reasonable in our pricing, and I believe over the years our clientele have been pleased with that. I would say, for someone who's a single person that doesn't have many assets, you're talking about maybe a few $100s, to a couple that, have a large array of assets, including maybe multiple properties, or, someone who has businesses. That could be a lot more. That could be a lot more money, because it involves extensive estate planning and many documents, most of which we've talked about today, but we haven't gotten into any real detail about trust, specific trust, and what they can do, what they can't do. But again, that could be a lot more money, well into the thousands of dollars, at least a couple $1,000s or more. Again, you can never be specific until you hear the needs of the clients, but we go over all of that with them. And the nice thing for them is I donate my hour of time free of charge. I will tell them before I ever do any work what the cost will be. They will know out front. They can then decide, do I want to do this or do I not want to? They have no obligation to do it. There's no cost if they decide not to do it. The only time they will have any costs incurred is if they tell me to move forward after they know what it's going to cost. So again, you'd almost call that as a no-risk informational meeting that we establish by them calling in, making an appointment, or coming by the office. And then after the meeting, we will tell them what it costs, and they will make the decision if they want to proceed and bear that cost.
Yeah, that sounds super fair, and it's sounds like to me the only risk is not doing this. You know, that's where the risk is. That's where the consequences are. Is not moving forward if you're in a category where you need estate planning, and it sounds like most people do, even if they're younger and have limited assets. Certainly, if they have children, but it's something that it's not going to hurt to give your office a call and investigate. And if you feel like now's not the time, you'll let them know that. And if you feel like now is the time, you're going to explain what they need and how much it's going to cost before anything is done moving forward. So, well, super helpful. We'll do more episodes, more programs along these lines as well as others. But thanks for your time today, David. And we look forward to talking to you again. Have a great day.
Absolutely, Mike. Thank you. Have a great day.